Good afternoon, everybody. Looking forward in just a couple of hours to having a chat with Pete Dassey, who has just finished visiting Brendan. I got to go and see him, so look forward to having a chat with Pete. I've been quiet for a while, been busy, but also it's been great to see all the other channels doing so much, particularly about the obviously the Court of Appeal's decision, and also not forgetting that unfortunately the 1st of August was the 1-year anniversary of the loss of Ericosi. So I really appreciate that there's so many channels remembering him and honoring him for the fact that he was the dude. Not least the fact that Mark was telling us, hot in it, that obviously there's been a couple of recipients of the Dude Advocacy Foundation. There's been a couple of people that have benefited or about to benefit from the trust that was set up. In case you didn't know this, after I watched the documentary in about February and March of 2016, I was particularly appalled at the fact that the actions of Manitrop County Sheriff's Department made all police officers look really bad. A lot of friends in the police force, and I just think it makes them look bad. It paints every policeman in the same way, and you know, the Lenks and Colburns of this world, you know, they're not the norm. Far from it. So I made a few inquiries about the Sheriff's Department, and after writing about 24 emails to Robert Herman, Sheriff Robert Herman at the time, I phoned him, and over the course of between April to September of 2016, I had well over a dozen very long conversations with Robert Herman, which were always we were always very respectful. It seemed at times to get on quite well, sharing the odd joke along the way. And as I say, it was pleasant. I did point out the things that particularly concerned me, and I pointed out to him that if you know, if he really thinks that his sheriff's department didn't do anything wrong, you know, that's going to get eventually, that is going to be shown to be the nonsense that it is, and that if he wasn't personally involved in the disappearance of Teresa and the framing of Steve, then he should be careful, because as head of the sheriff's department, you know, he could be the scapegoat. And he took it in his stride and thought, well, you know, he once said if Kathleen Zellner develops any proof of any planting by officers in his department, then he would contact Kathleen Zellner. I don't think he has to date, but the one thing that really struck me was, of course, midway, it was about August, one of the conversations that we had, he stopped me mid-sentence and said, listen, Paul, let me assure you, Mr. Avery, he always referred to him as Mr. Avery, never Stephen Avery, Mr. Avery will spend the rest of his life in prison, which, of course, I took as meaning various things. One, it was something that Robert Herman would say regularly to people who asked him about the case and brought up the anomalies that we all know about, You know, it would have been a standard line of his to tell people, don't worry, Stephen Avery will spend the rest of his life in prison. I find it quite a bizarre response, because as far as I know, the job, if you like, the duty, care of the police is not to convict people, it's to find the truth and to find out who the real perpetrators are. But I've heard this in other documentaries where a policeman or a detective, when asked on the witness stand, you know, what is your job? You know, and he said, well, it's to get a conviction. And it certainly does give you an insight into the mindset of law enforcement. They're only concerned about getting the conviction, same as the DAs. And obviously, famously, we've got Dawah Massey in the Adnan Syed case, who actually says, you know, the bar for arresting somebody is 51%. If you've got, you know, 51% of a case against somebody, then you can arrest them, because the bar is 51%. It's up to the district attorney to then do the rest. Obviously, he did stop speaking to me. I suspect he was being slightly more candid with me than he should. And it appeared to me that they then got somebody to act as his manager, who then you know, either deflected phone calls, or you know, you would be put onto the answering machine. But I never spoke to Robert Herman once Kathleen Zellner's motion for testing was gathering pace, and you know, we discovered some of the things about the well, I particularly remember the tweet where she showed us the microscope, and then it was revealed that it got, you know, wood and paint on this bullet. As I say, I just find it pretty bizarre that you know, he would come out with this statement. You know, rest assured, Mr. Avery will spend the rest of his life in prison. You know, if and when the evidence, or the evidentiary hearing produces the evidence to show that Stephen's innocent, then he's going to be out. You know, so that seemed a pretty bizarre statement. As I say, I took it as probably a mixture of two things. One, that it was something that he said, it was a standard line. Well, three things, in fact, sorry. One, that it's a standard line. Two, that it was a message to me to say, look, why are you bothering advocating for Stephen Avery? Just forget it. You know, you're not going to get anywhere with this. But more sinister, I think, of the three would be that he has got assurances further up the food chain that any attempt to get Stephen Avery out will fail. And I'm just wondering if, when the Court of Appeals made their decision, if it wasn't based, if that doesn't give us a good example of the kind of obstructions that have been put in place to ensure that Stephen Avery is, as he says, spends the rest of his life in prison. Yeah, I was a bit surprised at the decision. I know that we've had some tweets whereby Kathleen Zellner has said, well, you know, thank you for pointing us in certain directions, showing us which doors to go in, etc., etc. I think that's just being polite on her behalf. I'm sure that she's got that same controlled rage over the Court of Appeals she had in the Ryan Ferguson case. And she did tweet yesterday, although it's since been deleted, this Reddit post by Temp Tedious, which is excellent. And so let's have a look at what was posted, say, by Temp Tedious. Let me just do this. Let me just click on this. There we go. There we go. Click on share. Actually, just before we do that, there was something else I did want to share with you, which I particularly was pretty miffed about. Really don't like what's been written here, and this obviously, you know, following this case, because it had been Paul Riley who had looked at it so far, you thought, well, you know, he seems pretty fair. But then when Davis and Neubauer in particular, I mean, Neubauer has been part of the previous appeals court decisions. But this sentence here, this requirement promotes finality once the defendant has been convicted and sentenced, and minimizes time-consuming post-conviction hearings. You know, really appalling that you know, the once you're convicted and sentenced, that's it. You know, it's like a used car. You know, there's no money back guarantee. You know, you once it's sold as seen, and that's it. End of story. I'm sure that's partly what Robert Herman is basing his assertions on. But it just struck me, this whole business of time-consuming post-conviction hearings. You know, that it minimizes that their job, part of their job is to minimize, you know, the time taken to look at post-conviction hearings. Presumably, with there being so many golf courses on in Wisconsin, Kathleen Zellner should realize, you know, that these judges have got far more important things to do than worry about Stephen Avery. You know, membership of some of these golf clubs, and you know, can cost thousands and thousands of dollars per year. You know, they've got to make the most of these amenities and go and play golf. They don't want to spend time, you know, looking at the framing of innocent people when they can just hide behind these cases that they've quoted, and decisions where minimize time-consuming post-conviction. Well, that's pretty poor. I really don't like that statement at all. The fact that they've used it in their decision. Where's the humanity in that? What are you going to end up? A lot of false, you know, wrongful convictions. Anyway, let's let's have a look at this other. Let's say Kathleen Zellner tweeted this. No, not that one. Hold on a sec. Pressed on the wrong button. I'll try and get it right. Yeah, here we go. So this was posted on TikTok Manitowoc. And this was posted by Temptedious, and it's quite a long Reddit post. So let's jump into it straight away. And Zellner's post was actually quoting this opening. The Court of Appeal's denial of Stephen Avery's request for an evidentiary hearing is full of errors and omissions that strongly undermines confidence in the court's knowledge of the case and understanding of Zellner's motions and claims. So we do thank Temptedious for posting this on Twitter and on Reddit, and for Kathleen Zellner for sharing it on Twitter. In this post, I will list out 10 errors or issues in the decision and order authored by the Wisconsin Court of Appeal District 2, denying Stephen Avery his right to an evidentiary hearing. Yes, there are far more than 10 errors in the denial, but I had to start somewhere. The remainder of the post will expand on 3 specific errors that share a commonality. Each of the 3 errors examined reveals the court either missed or ignored important information included by Zellner in her filings. Before we begin, let's get some fluff out of the way. Was I surprised by this decision and order? Yes, I totally agree with Temp TBS. I was surprised. I didn't expect an outright denial of nearly every single issue. This definitely qualifies as an unfortunate setback, a little roadblock. Yes, the court decisions and order is full of errors. Will that matter when, if Zellner files a motion for reconsideration? Likely not. Either way, I don't view it as a waste of time to identify and explain the many errors or issues with the denial. And yeah, I would have to say that the one good thing we do have is, you know, a 50-page document that they have authored, and they've signed it on behalf of all three judges. And so they will have to eat this pie at some point that they've created, and that hopefully will be both problematic and embarrassing for them. So yes, let's hope that the next thing that Zellner does is file a motion for reconsideration, pointing out all of the things that they had got wrong, that the Court of Appeals had got wrong, in the same way that Angie has got wrong. Now, should anyone give up? No. When Sheriff Herman said to me, you know, Paul, let me assure you, Stephen Avery will spend the rest of his life in prison. That didn't put me up at all. Although he was trying to say, you know, why bother wasting your time advocating for Stephen Avery? Absolutely not. It just makes you want to go even more. Controlled rage? No, not a controlled rage. Sadness? Yeah, sadness in the fact that we've got a system over there in Wisconsin that can treat another person so badly. Should anyone give up? No. Even if Zellner had won her appeal, we would have been in for a long wait and another appeal by the state. Also, it's worth noting this same court in 1996, ruled against and denied relief to an innocent, wrongfully imprisoned Stephen Avery. I believe the same thing has happened again with the same court and the same defendant, no less, and hopefully the same eventual outcome. Hear, hear. Identifying 10 errors or issues with the Court of Appeals decision and order. It is now abundantly clear that TikTok, Manitok Redditors and Twitter users and you know, the whole community are more familiar with the facts of this case than the judges from the Court of Appeals. Unfortunately, I'm not joking. Let's put it this way. If a new user posted on TTM implying Avery could have burnt Teresa's body in his burned barrel based on the fact bone fragments were found in the said barrel, I have no doubt many users would correctly point out that bones were not found in Stephen's barrel, but were found in the Dassey barrel. In their recent denial, the Court of Appeals incorrectly claimed bones were found in Stephen's burn barrel, meaning the court was not appropriately familiar with the location of bone evidence while deciding an appeal for a murder case. I'm not going to swear. Okay, go figure. So, if you knew that bone fragments were found in the Dassey burn barrel and not Stephen's burn barrel, congratulations, you are officially more knowledgeable about the facts of this case than any judge from the Wisconsin Court of Appeals. 10 errors or issues. The court misspelt Teresa's name as Teresa. It's one of the worst things you can possibly do. Of course, I'm assuming this is an innocent mistake, but still, it is just bad. It looks bad. It is bad, especially when proper lawyers take the trouble to spell her name correctly. The court incorrectly claimed bones were found in Stephen's burn barrel, when in reality bones were found in the Dassey burn barrel. Luckily, the court is now on record suggesting the presence of bones in a barrel supports the theory that said barrel might have been used for the cremation. Yeah, I found this quite bizarre, that the Court of Appeals were coming up with a new scenario that wasn't presented by Kratz and Co. The court incorrectly claimed the state never said the bullet went through Teresa's skull. This is plainly false. State witness Jensen, in response to questions specifically about FL striking bone, testified that item FL had passed through Teresa's brain. Has the court not reviewed the trial transcripts? Obviously not. The court incorrectly said that Kathleen failed to address in her motion Court incorrectly said Zellner failed to address in a motion why Strang and Buting's strategy for explaining Stephen's blood in the RAV4 was constitutionally deficient. In reality, a detailed argument was made, but was totally ignored by the court. The court incorrectly said Zellner's argument about the swapping of swabs was not supported by any facts of record. In reality, there are many facts of record that support Zellner's argument, but again, were totally ignored by the court. Mysteriously, bizarrely, the court offered an opinion about the content of a missing voicemail that no defense counsel or judge has ever heard, while also ignoring a recorded phone call between police officers that directly contradicts the court's opinion about the content of the voicemail order of Teresa's appointments. The court incorrectly said Zellner never notified the circuit court judge or of her intent to supplement her initial 97406 motion. In reality, Zellner said very clearly said in the motion itself that supplements were forthcoming due to additional testing. Both the circuit court and the Court of Appeals have not thoroughly read Kathleen's filings, resulting in both courts offering the same erroneous opinion, essentially compounding their errors. The court failed to properly analyze Zellner's Brady claim regarding the late and deceptive disclosure of the Brendan Dassey computer forensic image, totally avoiding the argument that the state was acting deceptively by identifying the forensic image as a copy of Brendan Dassey's computer, when evidence revealed Bobby was the primary user. The court also grossly misrepresented Zellner's argument supporting her identification of Bobby as the source of the disturbing computer contents. Apparently, the court was utterly incapable of comparing the timing of image searches to Bobby's trial testimony about when he was home alone. 9, the court incorrectly concluded Zellner failed to demonstrate bad faith on the state's part regarding the destruction of biological evidence in 2011. In reality, there's nothing but evidence of bad faith. The court also dismissed Zellner's argument that Fallon misled her in 2017 to 2018 regarding whether or not the state still had the bone fragments. All those lies Fallon told Zellner about still having the bones in custody when he himself knew they were gone, surely the court only brought it up to say it didn't matter. The court incorrectly said Leslie Eisenberg testified at trial that none of the quarry bones were human. It seems the court is suggesting Eisenberg, after submitting her final report, which listed the quarry bones as humans, conducted an additional undisclosed examination during which she did a hard 180 on the origin of the bone evidence and then failed to report or disclose her updated findings prior to trial. In reality, of course, no such additional examination occurred, and the opinions listed in Eisenberg's final report that the quarry bones were human was not contradicted by her testimony at trial. This misrepresentation of Eisenberg's testimony resulted in the court, without question or concern, accepting the state's argument that they may have released non-human bones to Teresa's family for burial or cremation. After much consideration, I feel confident identifying this opinion as a steaming pile of manure. Although I don't know if it will help, I certainly hope Zellner files a motion for reconsideration, if for no other reason than to get on record about all of these embarrassing errors of facts and law, as well as the many examples of the court flat out ignoring the relevant aspects of Zellner's arguments. And again, going back to 1996, we had Judge Hazelwood at the appeals stage saying that, when they found this third allele, that, they couldn't rule out other people as being the source of this this DNA. Just bizarre. Anyway, Zellner's 97406 motion contains the exact information arguments the court says was not included. The court repeatedly failed to properly analyze Zellner's claims, leading to them improperly denying Avery an evidentiary hearing. It is important to note the Court of Appeals first and foremost frames their decision and order as an examination of whether Zellner's 97406 motions warranted a hearing based on the Allen test used to determine whether any alleged facts are material and sufficient. The court correctly notes a hearing must be granted if the motion alleges sufficient material allegations that, if true, would warrant relief. Zellner stated many such sufficient material allegations that, if true, would warrant relief. Example, Hoodlatch DNA was planted, blood was planted in the raft, Teresa left the Avery property alive. Now, to avoid making conclusory statements, any claim or allegation must be supported by some matter of record, which can be anything from an expert or civilian affidavit to trial testimony to police reports or audio files. All of Zellner's claims were supported by facts of record. This wasn't her first rodeo. She's been here before. Next up are the procedural bars to which the Allen test also applies. In my opinion, Zellner absolutely offered valid arguments regarding 1, the ineffectiveness of Stephen's trial counsel, 2, the ineffectiveness of Stephen's prior post-conviction counsel, and 3, a sufficient reason why Stephen himself could not raise these claims in his 2013 pro se self-authored motion. The court determined Kathleen overcame procedural bar number 3 for certain claims, but she failed to overcome procedural bar 1 and 2. Wrong, but whatever. The most troubling part of the denial is that even after giving Avery the benefit of the doubt and setting all procedural issues aside, the court somehow determined Zellner did not present any sufficient material allegations that warranted a hearing. Not a single one, I call BS. Let's review a prime example of the court's failure to properly analyze Kathleen's post-conviction claims. Blood spatter, demonstrating deficient performance. Although the court was dismissive of Zellner's experts, they did actually concede her blood spatter expert offered opinions that certainly support Avery's general theory and would likely have been helpful evidence to Stephen at trial, but determined such measured support wouldn't have resulted in an acquittal because, even if true, the expert's opinion wouldn't overcome the cumulative impact of the state's evidence at trial. In an example of supreme irony, not once did the court assess the cumulative impact Zellner's claims would have had on the jury, as is required by these cases quoted. The court also, while discussing claims concerning ineffective assistance of counsel, incorrectly said Zellner failed to address why Avery's trial counsel's strategy for explaining Avery's blood in the raft was constitutionally deficient. quote, Avery fails to demonstrate how the defense strategies that trial counsel did pursue rendered counsel's performance constitutionally deficient. As an example, he points to trial counsel's failure to obtain a blood spatter expert, but does not address why counsel's chosen strategy for explaining the presence of his blood in the RAV4 represented deficient performance. This is 100% false. Zellner did address this issue, but the court seems to have missed or ignored it. Before I explain myself, here is a brief review of trial defense counsel's chosen strategy. Dean and Jerry argued Stephen's blood was planted in the RAV by Lieutenant Link on November the 5th, who obtained Stephen's blood from the 1996 blood vial. This argument was fatally damaged when the state presented FBI testimony about a lack of EDTA in the blood samples, suggesting said blood did not come from the vial. Although the quality of Mark LeBeau's testimony findings does have to be questioned. Now, despite what the court said, Zellner very clearly explained in her motion why Strang and Butin's chosen strategy constituted deficient performance. Here is a summary of Zellner's detailed argument. Zellner first points to the defense failure to retain a blood spatter expert who would have told them to abandon their trial strategy about the source of the planted blood because there was no evidence the blood vial was tampered with, and the presence of blood flakes in the RAV4 rules out the vial as a source. Mr. James opines that the most likely source of Steve's planted blood was the blood deposited by Steve in his sink, and not from the 1996 blood vial. The court only addressed this portion of Zellner's argument to say it was speculative to assume an expert hired by trial counsel would have reached the same conclusion as her current expert. But such an opinion misses the mark by miles. Many cases, shown here, were cited by Zellner to support her position that the failure to consult expert witnesses was enough to demonstrate deficient performance. However, this standard only applies to cases where the state presented their own expert testimony, like the state did in Avery's case. Most, if not all, attorneys should know they don't have the wherewithal to adequately refute expert testimony on their own during cross-examination. There are times when the only adequate means of challenging expert testimony elicited by the state is to introduce contrary expert testimony in favor of the defense. Thus, the issue here is the failure of Strang and Butin to consult experts when they knew the state was going to call their own. That's it. Such a failure does not depend on what any expert would have opined had they been consulted. However, as Zellner explained in her motion, expert opinions can and should be used to bolster or support a post-conviction claim that had experts been consulted and called at trial, their testimony too far there. Their testimony would have been useful in overcoming the cumulative impact of the state's evidence. Sorry, let me read that again because it jumped a bit. However, as Zellner explained in her motion, expert opinions can and should be used to bolster or support a post-conviction claim that, had experts been consulted and called at trial, their testimony would have been useful in overcoming the cumulative impact of the state's evidence. Next, and perhaps most importantly, Zellner highlighted the failure of trial defense counsel to investigate Mr. Avery's claim that his blood was removed from his bathroom sink and planted in the RAV4. This is an incredibly strong argument for demonstrating deficient performance, as it involves counsel literally ignoring what Stephen told them about the evidence. And here's the kicker. If Dean and Jerry had listened to Stephen and investigated his claim, they could have fashioned an argument to explain the blood in the raffle that wouldn't have been impacted by Mark LeBeau. That would have been huge. As such, the failure to investigate Steve's claim about his blood in the sink absolutely constitutes deficient performance. This crucial aspect of Zellner's argument was totally ignored by the court. Finally, Zellner argued it was ineffective of trial counsel to suggest Lenk was the individual who planted the blood because there was no evidence that Lenk ever even knew about the 96 blood vial, and thus such a strategy was totally lacking in credibility because there was no corroborative evidence to support it. Kathleen also argued Dean and Jerry misrepresented facts about evidence transmittal forms and the broken seal on the blood's packaging to support their faulty argument. Once again, the court totally avoided this crucial aspect of Zellner's shrewd argument, possibly because the court realized they couldn't refute this argument without suggesting it was reasonable to believe Lenk may have planted the blood. Best to just ignore it. Like they did so many things. So instead of addressing and weighing these arguments relating to the deficiency of trial counsel, the court incorrectly said Zellner failed to make the arguments, Jesus Murphy, beyond misspellings of names and errors of facts. Stuff like this really gets under my skin. I'm sure Zellner was beyond frustrated to learn she included in her motion the exact information the court says was missing from the filing. Now, we've got a long way to go. So I think we'll just call this part one and carry on with part two probably tomorrow. But as I say, looking forward to having a chat in, well, as the time is now, about 2 hours time with Pete Dassey, find out how he's getting on with, how he got on with his visit to Brendan. So yeah, let's just call a halt to it there. Excellent stuff, again, by Temptedious on Reddit, on TikTok Manitwalk. It's taken a wee while to really sink in, think about what this Court of Appeals decision is all about. I'd like to think that, as I think it was Tracy Strunsey pointed out, that there were elements of it that to her felt like the Court of Appeals were just giving her, Kathleen Zellner, a little nudge, saying, you know, try this, do this, do this, do this. Maybe let's wait and see. Certainly, they've suggested obviously carry on with the Thomas Sawinski situation, but I'm pretty sure that it's right that Kathleen Zellner should first of all appeal and point out all the errors that the Court of Appeals has made, and so go for a motion of reconsideration. You know, having argued with them. You know. Anyway, let's say we'll carry on with possibly a part 2, 3, or 4 of that particular post. Excellent, and we'll see you all again soon. Well, very soon. Less than 2 hours. Bye for now.